I think it's a real patient win to be able to try to communicate with payers and get onboarding of new drugs and greater patient access earlier. Um, and I'm hopeful that companies will continue to leverage the statute and the guidance and move forward with those communications and help ensure additional patient access.
Hi, everyone. I'm Virginia Foley, founder of Compliance Forward, and today I'm joined by senior consultant Jason Kober and our very special guest, Dara Katcher Levy. In June, FDA published a new draft guidance on the topic of healthcare economic information, or HCEI, communications with payers and formulary committees. This guidance represents a revision of a final guidance on the same topic that was published in 2018. On today's episode, we're going to break down the history of FDA's guidance on payer communications, discuss why the agency has decided to revise the guidance now. So let's get started. Dara, I've worked with you for a long time, but for those of you who may not know you, what's your background? And just tell us a little bit about your history with the FDA and the payer guidance.
Sure. Hi, I'm Dara Levy. I am a director at Hyman Phelps and McNamara, which is a dedicated food and drug law firm. I've been with the firm for 25 years now, so it's been a while. I primarily work with pharmaceutical companies and medical device companies on structuring compliant prescription product communications, and have been working on payer communications since the start of my time. So before even the first draft payer guidance came out in 2017. And I think that this was a really welcome document on the part of myself and industry in being able to provide good quality guidance to pharmaceutical companies and medical device companies, so that they could effectively communicate about upcoming products for payer coverage and make value-based statements about the products that they were offering.
So, Jason, you worked in the OPDP policy division when the previous version of the payers guidance was being drafted. I'd love it if you could talk about the history of the payer guidance from that perspective.
Sure. So I think it's important to take a quick look at the timeline of publishing before we do any kind of analysis, because I think it's important to understand how we got where we are today with the current version of the payers draft. As Dara said, the first version of the guidance published in January of 2017, that was the draft guidance. And one of the remarkable things about this particular guidance was how quickly it went from draft to final. So we see that it published in its final version in June of 2018, which is really remarkable. And I believe Dara wrote about this in an FDA law blog too, that this happened in about 18 months. And what stands out to me about that is one, is a testament to the skill and the knowledge of OPDP's policy shop, but also the leadership of the agency at the time. And I think you contrast that to where we are today. It really stands out, and it's a demonstration of why policy shops are so critical to FDA, what they can accomplish, what they can do, and why it's so important to have these policy roles in FDA. You can see how in 2018, the agency was able to execute on their aspirations, their goals to get this guidance out, get it into a final format. And that really contrasts to where we are today. The agency is really focused on talking about things that it wants to do, but it just really hasn't been able to do a lot of the things that they say they want to do. But setting that aside, we move on from June 2018. We see that even though that guidance was published in its final format in 2018, I think the perception from the agency was that there was a slow adoption, a slow uptake of the recommendations that were in that guidance. So in March of 2022, the recommendations that were in the final guidance, in addition to some other recommendations, were incorporated into the Pre-Approval Information Act, or the P.I.E. Act, which started out in the House of Representatives, but it was connected to the Appropriations Act that reauthorized the user fees in 2023. the PI Act was passed. It was signed into law by President Biden on 12/29 of 2022. It was implemented in the Consolidated Appropriations Act of 2023. And the reason that that's important is this is really the motivating factor for the revision of the Payors Guidance now in June of 2026, because as we all know, in most cases, the typical life cycle for policy is Congress passes a law, there's regulations, and then the individual agencies will issue guidance that kind of operationalizes either the regulation or the law. In this case, is a really interesting case where Congress actually picked up many of the recommendations that were in the guidance, and then they implemented them in law. So what we're really seeing here in the June 2026 version of the Payors Guidance is the guidance is really being brought into conformance with the PI Act. But before we get into that, I think it's really important to talk about what happened after June of 2018. And this is where I want to hand it over to Dara. I'm curious, what was industry's perspective coming out of June of 2018? One, this guidance obviously went to final very quickly, but I'm curious what industry's initial thoughts were in June of 2018 when that guidance went final.
I think that there was some mixed feelings about the guidance. I think that everyone welcomed it, but there was definitely some new information in the 2018 guidance that wasn't in the 2017 draft guidance. So the 2017 draft guidance had sort of opened the door for communications about wholly unapproved drugs, in discussions with payers. It was silent about unapproved uses of approved drugs. That was added into the final guidance in 2018. So it wasn't as if, industry had an opportunity to sit with that for 18 months, pending the finalization of the guidance. And so now we have this final guidance. And whether you're talking about unapproved drugs or unapproved uses of approved drugs, which represents a much more substantial risk to pharmaceutical companies when having what FDA would consider to be "quote unquote" promotional discussions in terms of conveying, healthcare economic information to payers. I think that there was a lot of uneasiness with whether or not a guidance could trump a regulation that prohibited the commercialization of an investigational drug. So you have, pre-approval prohibitions that are in law and regulation, and then you have a guidance that's saying, no, it's okay. We're going to exercise enforcement discretion, and while that's great, it's guidance, and the front part of every guidance that's issued by the agency makes it very clear that it's not binding. So there were no real legal protections in place for this communication other than, this guidance document. And there were many concerns about whether or not communications about, I think, particularly unapproved uses of approved products, could be viewed as off-label promotion and could open up companies to False Claims Act liability. So, very, very helpful to have the guidance, but much more necessary to have some type of change in the law that would provide legal protections for companies when communicating about unapproved uses.
Perfect. I mean, that's kind of what I remember too. When I saw the guidance, I was very excited about it and thought it could really be a game changer. And just seeing how companies adopted it, from controlling the messaging, controlling the people, making sure they're skilled and able to talk to the payers, I think was part of what I saw. But I was also working at a company that at the time that really needed that push to be able to talk to payers. It was critical. So what's new in the draft payer guidance? It's so weird. I was like, final draft, final. We're leapfrogging here. So what's new in the draft payers guidance that just came out this year?
I think the draft payer guidance incorporates the new statutory provisions in 502GG that are specific to being able to communicate about investigational drugs and devices. And it's interesting because the guidance makes it makes a distinction almost between the language in the statute, which is investigational, and the language in the guidance, which is unapproved. And I thought that that was really interesting. I know that one of the types of unapproved products that they reference in footnote are products subjects to ANDAs. And I was wondering about that and whether or not that's intended to kind of cover unapproved generics that may not have INDs open for them and may not be considered, traditional investigational drugs. But I just thought that was interesting. I think the guidance also moves up the discussion of the substantial government interest in getting approvals for therapeutic products. They moved it from a Q&A that was relegated to the end of the final guidance in 2018 on unapproved products and unapproved uses, and they moved it up to the background section of this draft 2026 guidance, I think, to just reinforce the importance of seeking approval from the agency for these products and ensuring that the public at large is getting safe and effective treatments.
So from a policy perspective, Dara, do you think that this new draft guidance has introduced any new policy concepts that industry should focus on?
I think that one of the interesting things is they have grouped together the unapproved use and unapproved product concepts together. And in the 2018 guidance, these were considered separate categories. But in the draft guidance in 2026, this is grouped together as a whole, and they're making distinctions between the two. And I think one of the important takeaways is that FDA does not want companies to be speaking to the FDA approved status of a product when they are talking about a new investigational use of that product. So I thought that that was a really interesting takeaway. Oftentimes companies say, well, it's approved for this use and we have the following uses under investigation. And my takeaway from this draft guidance is, no, we treat the investigational uses or the unapproved uses as separate and apart from any FDA approval status, because that's a completely separate intended use.
That is a big change. Do you think companies shouldn't be using the trade name if they're talking about investigational uses?
I don't think that companies should be using the trade name. I can understand why there might be needs, but especially if we're talking about approved products and unapproved uses, I don't think that there's a need to be referencing the trade name. And I believe OPDP has previously cited companies for the use of a trade name as the commercialization of an unapproved drug. So I think that that's probably consistent. I'm more along the lines of, for approved products and unapproved uses, the trade name should not be used.
Okay, that's a good takeaway. Thank you. So we've talked a lot about this guidance. We also had the biosimilar final guidance come out. Are we picking up any sign here that OPDP's policy development operation is restarting? Maybe we're going to see some additional guidance into the future? I know you don't have a crystal ball, but any thoughts on that?
Yeah, I don't think so. So for those who haven't been following closely, the entire policy division in OPDP was subject to the reductions of force on April 1st, 2025. So that entire division was eliminated concurrent with the reductions in force. What we've seen coming out of the agency with regards to ad promo policy has basically been things that the agency has to do. And that's kind of a generalized term. I wouldn't say it's binding on the part of the agency. But what I mean by that is when you look at the biosim guidance, for example, there was a user fee commitment to publish the final biosim guidance by December of 2025. So they had to publish by that date. That was the target date to conform with the user fee commitment. Same thing with the payers guidance. Again, as we said, much of what we saw in the P.I.E. Act was taken from the 2018 Payors Guidance, not all of it. It does introduce some new concepts, as Dara alluded to. But the final Payors Guidance had to be updated to, one, cite the 2023 Appropriations Act. It had to be updated to cite 502GG. It had to be updated to incorporate devices. So there were a number of things that had to happen to bring it into conformance with the P.I.E. Act. But I would argue that these are not things that the agency is choosing to do. This is more things that they had to do. So no, I don't see it as a signal that the agency is going to be restarting their policy. I would also say that they've articulated a number of things in press release and communications publicly that I think the agency has cited as priorities. And the question is, why have they not done those things yet, as opposed to getting these things out that are kind of, pretty straightforward. So no, I don't think it's a sign that we're going to see new policy coming out of FDA at this point.
I agree. So Dara, we're kind of wrapping up here. It's been so awesome having you here. We've been really looking forward to this talk. You're such an expert in the space, so I really appreciate you sharing your time with us. Is there anything else, any nuggets you want to leave us with that we didn't ask you about that maybe industry should be thinking about?
To say, I think that the evolution of payer communications has been pretty substantial over the past decade. As I was talking to you earlier about, even prior to the 2017 draft guidance, we had senior leadership within the Center for Drug Evaluation communicating to industry about how they could apply the competent and reliable standard to their communications with payers. And there was a lot of confusion from those I think communications from senior leadership in that they were indicating that the competent and reliable standard, which is not defined in the Act and still is not defined in the Act, should not be used to masquerade comparative claims of efficacy or safety, and that it's limited to value-based statements. And I think that led to industry not understanding sort of how to apply the standard to the inputs that might go into a value-based claim, which might be looking at efficacy or safety. And so there were questions about whether or not you had to use substantial evidence that would then go into an algorithm that would then create a value-based statement that was competent and reliable. So the guidance document that came out in 2017, 2018 was really helpful in clarifying for industry, no. All of your inputs, including your efficacy and your safety inputs, can be subject to the competent and reliable standard. And then I think, FDA went further and explained what it understood competent and reliable to mean, since it wasn't otherwise defined in the statute. And I think that was incredibly helpful for industry. So, as we look at like the 2026 document, we're seeing a continued evolution based on, the changes that were made in 502GG. But we're not really seeing sort of FDA go out on a limb here and breaking any real new ground in terms of, what industry can better understand or what industry can better do. It's really just incorporating, as Jason said, the provisions from the P.I.E. Act into the guidance document. So, I think it's a watch and wait. I think it's a real patient win. It's a continued patient win to be able to try to communicate with payers and get onboarding of new drugs and greater patient access earlier. And I'm hopeful that companies will continue to leverage the statute and the guidance and move forward with those communications and help ensure additional patient access.
Thank you so much, Dara and Jason. This has been the Promotional Intelligence Podcast. We try to take our topics and break them down for you guys to be able to have some practical applications in your work. If you like what we're doing, let us know. Please like and subscribe to our YouTube channel and connect with us on LinkedIn. We're pretty easy to find, and we'll help you stay up to date on all things regulatory. Thanks so much, everyone.